One theme seems to be picking up on the birthright citizenship matter, something like time's up, but for the 14th Amendment, as well as some but actually the 14th Amendment. So there seems to be like this cockamamie idea that the 14th Amendment had an expiration date when it comes to protecting the rights of, I don't know, racial minorities and anyone who isn't Pete Hegseth. These folks do think that the 14th Amendment does contain one permanent principle, which prevents the government from protecting civil rights. Like, this is literally, if you spell it out, the new vision of the 14th Amendment is one where the 14th Amendment's protections for civil rights were subject to an expiration date, which is now, except when the 14th Amendment declares anti-discrimination laws to be the new discrimination. No expiration date on that baby.
So this should be really familiar to you all because we have talked about this. This is an ongoing theme throughout many terms on this court, but it really does seem to be reaching a fevered pitch. And one case where I think it's going to be especially apparent is in Louisiana versus Kelly. This was a case from last term that has been held over for this term, and the court has apparently decided that it needs to determine, in the context of this case, whether Section 2 of the Voting Rights Act, this is the part of the Voting Rights Act that is a nationwide ban on discrimination in voting, whether, in the context of Section 2, the consideration of race in remedial measures for voting discrimination is in fact unconstitutional. That seems like a pretty modest ask, like letting racial minorities have a say in our democracy. But apparently, even thinking about race as you try to construct a system that is fair to minority voters is apparently a bridge too far. So thinking about race as you try to remedy racially motivated vote dilution is apparently now illegal, unconstitutional race discrimination, or it might be if some portion of this court has its way.
These justices, including Brett Kavanaugh, claim to be originalists, right? They say they think the meaning of the Constitution was fixed when the document was drafted and ratified, and yet they somehow seem poised to embrace the theory that the Voting Rights Act was constitutional when it was passed in 1965, maybe when it was amended in 1982, but that the same constitutional provision, which to be clear, hasn't changed, the 14th and the 15th Amendments, now don't allow the Voting Rights Act in 2025, right? So if we're being technical, it really sounds like a vision of the Constitution that is evolving or like devolving rather than originalist.